record in the matter of the state of Michigan versus Giannina Ballerini, 5-0893. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. I have to make a motion to practice under Michigan Court Rule 8.120. I have APA Abigail Tepper to my left in the jury box.
Good morning, Your Honor. Attorney Derek spoke on behalf of Mrs. Ballerini.
Motion's granted. Let's see, is Ms. Ballerini?
Your Honor, she is in the Eaton County Jail, and she's having some mental health episodes that I can put on the record. My intent, based on the information provided by CMH CATS, is to refile a petition for competency, and I can put some reasons on the record.
Okay, it looks like they were still waiting for some records in July. Except for PCC, but he wants to be. This file. Do you have another file? Okay, if that's the case, a copy of that needs to be in this file. Because the last thing in there says on this case number, it is, I don't have a report in this case number that says she was found competent.
Last hearing, Your Honor, she was went on the record with stipulated report. Mr. Riley did. She does have a felony file with me and a misdemeanor file with Mr. Riley.
Yeah, that wasn't on this case number. So there's nothing. This case number had its own recommendation and report 25-00893. The last thing that I have in this file tells me that a report was in progress. That was as of July 11th. So we've since seen a report that was on the record. I must not have had this file, and it's not in this. It's not in this file. So she was deemed competent. You want to have her reevaluated?
Yes, Your Honor, reevaluated. We did receive an email, my social worker at the office, through the CMH CATS. It came from Anna. Email, for the most part, states she is currently under an initial outpatient treatment order. At this time, she is non-compliant with both her prescribed medications and mental health services. Her mental health status has notably deteriorated because of non-adherence to medications. Given the concerns and her ongoing decline in mental health, I will be moving forward with following the necessary documentation to initiate a psychiatric hospitalization. I do not have a final order from Judge Jennings from probate court, but you can get the order from her. This email was from a Monday, I believe, Your Honor. We are in the process of trying to get copies of the probate order.
Okay. Sounds good. Okay, and there obviously is no objection from the prosecution for the defendant to be reevaluated based on the observations and indications of her counsel.
Correct, no objection.
Okay. We will adjourn this proceeding. I don't know who's giving me feedback, but they are going on. I'll adjourn this proceeding while we await additional information from the probate court. And you have an order for her to be resubmitted for competency evaluation?
Yes, Your Honor, we will resubmit the petition and proposed order as soon as we get the probate order to include with the petition.
Any additional matters for today's case?
Nothing on behalf of the people.
No, Your Honor, thank you.
Thank you. You're all set.
Thank you, Your Honor.
On the record in the matter of the state of Michigan versus Lance Richmond, 25-02158, appearance, please.
Haley Fortuna Gill on behalf of the people.
Jamie White here on behalf of Mr. Standing my record.
Your Honor, an Assistant Public Defender, Sarah Donnelly, on behalf of Mr. Richmond in file 25-02015FY.
Someone crossed out the name and put White, but did he get a substitution of counsel?
Yes, you should have, Your Honor. Our office signed one and submitted it. I'll make sure that it gets to you.
I believe it's been submitted.
I've not yet received it. Did you see that you received it?
Trying to see if it's on this file.
Oh, is it in this? Locate, let's see if we can locate that. Mr. White, you're on which file?
I'm on the older file.
It's 2158.
Okay. So you're on the newer file.
No, I'm on the older file.
2158, the other one is 2015. So you're on the newer file.
The reissue,
The
right?
newer case
I'm on
number.
the, oh, I'm sorry, yes.
Yeah, I don't know anything about the facts. I'm
Right,
just going by
right.
case number. Okay.
Yes.
This was the date that was scheduled for a probable cause conference. Our vote was supposed to be on this project today. Let me see, 2158, oh my God.
The other one is just scheduled for an exam.
The other one is scheduled for what?
Just scheduled for an exam next week.
Next week? No, I do see that. Ms. Donnelly, your file is scheduled for exam next week.
It's my understanding that we set both of these for a probable cause conference preliminary exam, but if that's not what the court did, then I understand.
You just said it for a US form exam, but I think we needed no probable cause. But since you're both here, you can explain how you want to proceed.
Thank you, Your Honor. At this point in time, we would respectfully request to waive our right to have this exam in 21 days. Next week, I have an engagement, a professional engagement that is not flexible. It's been scheduled for quite a long period of time out of state. And in addition to that, after speaking with the defendant yesterday, he provided me with some documentation that's been see from recent police departments that he's going to require some additional discovery to prepare for the preliminary examination. So I am asking for a new date. I have discussed this with your clerk, with the court's permission. She's provided that date.
Okay, and Mr. Richmond, is accurate, you are willing to waive your 21-day right to have your exam?
Yes, Your Honor.
Okay, and no one's forcing or threatening you to do that, correct?
No, Your Honor.
Okay, Ms. Donnelly, you want to continue your exam next week?
Your Honor, I would be happy to continue my exam next week, but I got an issue with discovery. I've asked several times for the main officer's body worn camera and dash camera footage, and I haven't received it yet. It's very imperative that I review that for a search issue that I'm looking into. So if I can get it, I'd be happy to run it next week, but if I don't get it in time, then I won't be ready.
Your Honor, check and see if I have that dash cam. At this time, I will shoot an email right this second to get it if we don't have it. I'm not sure why we wouldn't have it. What officer's body cam specifically?
When she made a request, you don't have her request?
I do not have the request.
When did you make the request?
Well, obviously it was part of the initial demands, the video. I've gotten shared a lot of videos. It's just none of Officer Fox's. So I've emailed a couple of times to the prosecutor to remind her to look into it. I guess the first week, when we had that preliminary exam that first got adjourned, Fox was unavailable. I guess he was out that whole week. So last week I reminded her again, and I still don't have it.
Your Honor, I would have to imagine if we don't have it, that it doesn't exist. I'm
No,
going
I'm not gonna
to
imagine
reach
that.
out
I'm
again.
not gonna imagine that. You didn't even know you had an email. Looking for it.
But she's replied to my email. So she's
Yeah.
saying she's gonna check in with Fox.
She just said on my record today, what officer were you looking for? So she represented today that she wasn't clear on who you was even looking for. So I'm not gonna imagine, I'm gonna need to make sure and assure the court that we don't have body worn camera. And I don't see why there wouldn't be body worn camera.
Your Honor, I'm not at all trying to say that we don't have it. I apologize for that misunderstanding. I don't think I was clear enough with my words. I do have emails from Miss Donnelly. I have reached out to the police department. I'm checking that now. And I am going to reach out again right now to try to get that body worn
This is a
camera.
traffic stop that happened not exactly a month ago. So there shouldn't be a retention issue. There was a request to preserve it. And I think the policy is that when you make a traffic stop, you're supposed to activate your body worn camera.
And the dash cam is also.
Okay, so we will convert your next week to a probable cause conference so we can find out where your camera
Okay.
is, or your video is. And then you already got your new date, Mr. White?
Yes, I do, Your Honor.
What is that date?
September 11th at 9.
That's correct, Your Honor.
Let's give both of these September 11th for exam dates. And you can appear for your probable cause conference on the file that Ms. Donnelly is representing you on via Zoom next week, okay?
Thank you, Your Honor.
Any additional matters for today's record?
Not on my file, Your Honor.
Nothing on behalf of the people.
Not for defense.
Thank you.
File will continue, you're all set. Let's see, on the record in the matter of the state of Michigan versus Tammy Shaw, 25-02274, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Assistant Public Defender John Lee on behalf of Tammy Shaw.
Tammy Shaw is present via Zoom from the Ingham County Jail. This was a probable cause conference for police officer assault. It's scheduled for an examination next week on the 14th at 9 a.m. Are we continuing?
Yes, Your Honor.
Any evidence or for them?
No issues with the evidence, Your Honor. We would make one request in regard to bond. Ms. Shaw is currently on a PR bond, but she has a $25,000 cash bond out of the 55th District Court. So she's probably not going to be able to post bond. We're asking for a low 10% bond, so she can get credit for time served.
Bond is limited to 510%. Ms. Shaw, please stand up and move your body so that the motion can put the light back on. Thank you. Do you have any questions for the court?
No, I don't, not right now.
Okay, any additional matters for the record?
Nothing on behalf of the people.
Thank you, you're all set.
Thank you.
You're welcome. Is Edward Nicholson here? Or do we know what we're doing? Mr. Lee? Is he on there? What's leaving on? Edward Nicholson. At 9:30?
Yeah, that's the
Okay, I see the one for this and the other one for Lewis as well. Okay, sounds good. On the record in the matter, let me see who I put in here. Okay, on the record in the matter of the state of Michigan versus Carlos Diaz Torrens, 25-02211, appearance, please.
Good morning.
Is
Good
Mr.
morning.
Freeman here?
logging from the office.
Okay, Mr. Freeman's not here. Mr. Torrens, we're gonna put you in the waiting room until your attorney appears. On the record in the matter of the people of the state of Michigan versus Isaac Gonzalez, 23-00752.
Haley Fortuna Gill on behalf of the people.
Morning, Your Honor, Dan Doyle on behalf of Isaac Gonzalez.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Isaac, on behalf of Isaac Gonzalez on case numbers 25-02282 FY and 24-01161 FY. Mr. Gonzalez is present. He's appearing by Zoom this morning, polycom from the Ingham County Jail.
Okay, he has 3 separate files, carrying concealed on one, possession of meth, and then there's assault, murder. My understanding, Mr. Starks, was that your files were going to continue to exam. Is that accurate?
That's correct, Your Honor. We have discovery. Will be prepared next week. I will note that Ms. Sines, Isaac's mother, is present in the courtroom. She's in the back. She is a complaining witness on a potentially separate matter. Thank you.
Okay, thank you. Mr. Drew.
Yes, Your Honor, we will also continue the matter to the exam.
Okay, looks like the exams on each of these are for August 14th at 9 a.m. Person at the court. Any additional matters for today's record?
Nothing, Your Honor.
No, Your Honor, thank you.
Nothing further, Your Honor. Thank you.
Hans will continue. You're all set. You're all set, Mr. Gonzalez.
So good. How's it go? Where?
You are good to, yes, you are good to go. On the record in the matter of the state of Michigan versus Xavier Boland 25-01232. Appearance, please.
Haley Portillo on behalf of the people.
Darren Robinson, Assistant Public Defender on behalf of Ms. Boland.
Okay, this was a matter that I believe Mr. Milks was going to speak to you about. She appeared, I believe, late one day, that the last time she was supposed to be here, you were already gone. Mr. Milks stepped in, and there was always an issue with the plea, because she did plead to a reckless with the perception, I believe, that she could get a YTA, which it's not offered for driving offenses. So she was going to discuss if she wanted to withdraw her plea or not. So I don't know how we're proceeding today.
I think she wants to go forward with it.
She wants to move forward with the plea?
Yes.
Okay, you can make allocution.
Yes, Your Honor, we'd ask the court to follow the recommendation put forward in the PSI and sentence Ms. Boland to a term of probation for 6 months. I believe that she would be a good candidate for probation. She is currently working and doing well at her job. She understands that the offense that she committed was wrong, and she's willing to take the safe driving class in order to rectify that. So we'd ask the court to follow the recommendation.
The client want to make a statement at all?
No, she does not.
Where's she employed?
Amazon warehouse.
Oh, I think she told me that one. Okay, I remember now. Okay, I will adopt the recommendation. I find it to be appropriate. The sentence is 6 months probation. While on probation, you're not to use, purchase, or possess alcohol or drugs. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. And you're not to engage in any assaultive or threatening behavior. You are required to submit to random preliminary breath testing and your analysis testing. Remove that one, Gonzalez, since he's not doing anymore. And your analysis testing. You understand that? You're responsible for the cost of that, okay? I am going to order that you participate in the decision-based driving level 2 and you need to do that within 90 days, and that you maintain your employment and provide verification to your probation officer, okay? Do you have any questions? There's a $30 per month oversight fee for each month of probation that you are responsible for. $75 crime victim rights that you are responsible for, plus $50 state minimum cost. Your total fines and costs will be $305 because I'm going to waive discretionary fines and costs, okay? Let's see, did you complete? Are you currently in school?
No.
You didn't complete high school? Well, you're going to be ordered to complete it. While on probation. Do you have any questions? Okay. let's see, you'll check in with probation officer before you leave, Ms. Bayless. And you'll be reporting monthly via Zoom. Lastly, there's an advice of rights as to probation. Can you pass that to me, please? Thank you. It says you have the right to request early discharge once you completed half the original term ordered by the court. So after 90 days, if you've not made or had any violations within those 90 days, you can make a request to be discharged early, okay? But you have to have completed all of the programming that I just ordered you to do. That means that you have to have completed your driving course. I know I just ordered that you do complete high school. If you're enrolled and you are consistently participating, I'll consider an early discharge within 90 days, okay? Do you have any questions? If you want to make a request for early discharge, you need to use the court's MC 512 form. That's on the court website, or you can get it from your probation officer. If I set it for a hearing to address your request, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court appointed counsel for that hearing, okay? Any additional matters for the record, counsel?
Nothing, Your Honor.
No, Your Honor, thank you.
You're all set, thank you. Mr. Freeman is here for Diaz-Torrance and.
Yes, Your
Do
Honor.
you need to speak, do you need to speak with him?
I do not. Thank you.
Thank you. On the record, in the matter of State of Michigan versus Carlos Diaz-Torrance, 25-02211, appearance, please.
Good morning, Your Honor. Assistant Prosecutor Abigail Tepper appearing on behalf of the people.
Thank you, Your Honor. Stephen A. Freeman, Public Defender on behalf of Mr. Diaz-Torrance.
Okay, Mr. Torrance is present from Ingham County Jail, and this was a probable cause conference for multiple counts of criminal sexual conduct, first and third degree. We just 4 counts first, 4 counts on the third degree. It's scheduled for an exam on August 14th at 9 a.m. Are we continuing to examine?
Your Honor, I believe there's a discovery issue. There is a need for a protective order in this case. I did send it to Mr. Freeman this morning and he gave me approval to sign it on his behalf. If I could approach with that for your approval. Thank you.
Mr. Freeman, you received a copy and signed this, correct? Or you've given her permission to sign on your behalf?
Given permission, yes, Your Honor. Thank you.
Okay, I'm going to sign and authorize the protective order so that the discovery can be turned over. And that's available to be turned over immediately.
I will ensure it gets contacted with Mr. Freeman today for his office to come pick up.
Okay, so.
It is ready.
Okay, do we anticipate running an exam next week?
Yes, Your Honor. That would be the defense position, is to go forward next week.
I note that we're continuing to exam at this time. Any additional matters for today's record?
No, thank you, Your Honor.
Your Honor, if I may, my client's being held in the Ingham County Jail without bond. And as we all know, the court rules state essentially that he's entitled to have a trial within 90 days. It can save everyone a lot of trouble, difficulty if, excuse me, if this court would amend his bond to a significant cash or surety amount, of course, but something other than no bond, if that would please the court and if the people have no objection.
Your Honor, I would have no objection to changing the bond to a cash bond. However, I would also request that it be a high cash bond. For criminal sexual conduct, first degree charges with a 13-year-old child.
Bond is admitted to $300,000 cash surety with GPS tether.
My thanks to the court.
Thank you. Any additional matters for the record?
No, Your Honor.
All other bond conditions, including not being near any parks, playgrounds, or children, or where children are to be found, will continue. You're all set.
Thank you, Your Honor.
Thank you. Mr. Oaks is here with Nathan Norris. On the record in the matter of the state of Michigan versus Nathan Anthony Norris, 25-00880, appearance, please.
Lee Fortuna Gill on behalf of the people.
Michael is appearing on behalf of Nathan Norris, who's present to my right.
Okay, Mr. Norris was scheduled for sentencing today. Let's see. I have a copy of a pre-sentence report that was prepared on the 29th of July. Counsel, you got a copy of that?
Yes, Your Honor, no additions, deletions, or corrections to said report.
Make allocation.
Thank you, Your Honor. Your Honor, in this situation, my client regrets that he engaged with the bouncer at the club. He should have just left when he was directed to leave. He's gainfully employed, Your Honor. There's no services that probation would provide for him. It's just a one-off situation. He was out with his significant other, and this situation happened. So we ask this court to consider giving him a fines and costs. He does have a number of trips that was already paid for, leaving the country. One in I believe October, and then another in November and December. So we ask this court to consider giving him a fines and cost resolution.
Did your client want to make a statement? Why are you chewing gum?
Just a little embarrassed to be here today from the situation.
Your voice is really low, so I only heard that you were embarrassed to be here from a situation, but I didn't hear anything after that.
Oh, I just said that. Sorry, I've been in this situation in a while, and just embarrassed with the whole thing. And, real upset with myself about the situation.
This is happening at a bar or?
Yes, the Avenue over on Michigan Avenue. Situation in which my client says that the bouncer used a slur towards him and he reacted. And he should not have done that, no matter what was said.
The bouncer, did he put his hands on you?
Afterwards.
He used a slur and put his hands on you first, or what happened first?
No, it just.
He used a slur, and then you reacted. I don't know. I don't know what the slur was. I can only imagine. I'm looking at your prior criminal history. I haven't seen any recent engagement, at least not in the last 12 years.
That's correct. And he just got his expungement. So that's where he was really just upset with himself, because he just got an expungement, got his record clean, he's a barber, he's looking to try to get his own barber studio, so he can turn from renting a booth to be able to rent booths out to others. So he realized the importance of having his clean record, being able to get business loans and so forth. And so that's what he was expressing when we talked yesterday, as far as how he's really kicking himself that this happened, because he's not one who normally goes out. You don't go out, you don't really drink. This is a situation where others encourage him, come on, let's go out, and this happened. So he really just kicking himself. So that's why I was trying to get him to share with you, because that's what he shared with me yesterday.
I can imagine, and I can understand how sometimes words can incite actions. But as an adult, things that we should process regularly is how we react to people, especially when we're talking about words, because you have and are well within your right to use your words back to address someone who makes comments to you that are ignorant, that are degrading, that are offensive. But if you're not at a place where you can control your emotion when that happens, then you do need some oversight, because we need to maybe get you some anger management, maybe get you some tools that you can use, because I can't guarantee you, I can almost promise you that there'll be other times that people are going to call you out of your name and maybe degrade you, especially in the climate that we're living in now. You need to have enough, and I shouldn't say thick skin, because no one deserves to be called a slur, whatever the slur was. However, you need to be in a position where you learn to use your words to redirect and correct actions. And then sometimes understand that silence might be the best way to resolve something, because there's been times where people have engaged in people and they've lost their lives. And so is it worth it? Is being in court today on an assault and battery worth it? And the person who degraded you is off scot-free. So you really have to start to consider how your actions affect you. You're the person you need to protect. And I understand words are hurtful, but it's not worth you putting yourself in a position where you can really affect your livelihood. It sounds like you're young and you've got a good head on your shoulders. It looks like you've had some issues in the past that you've been doing some redirection on, and that you're working. You said, is it a barber shop that you're working at, Trice headquarters?
Yes, I'm actually co-owner of the barber shop.
Okay, that's the name of the barber shop. Where is that located?
Waverly, South Waverly, 325 South Waverly.
Who's the owner? Who do you own it with?
Actually, my own. Antonio Trice.
Antonio Trice.
Yeah.
Is related to Larry Trice from Tabernacle?
That's my family.
Okay, yeah, I think I know who Antonio Trice is. Let's see. And you're working to open your own?
Yes. I've been with my uncle for a while now, so I just want to branch out and get my own shop. Learned a lot from him. Just, have a little more for me and my kids.
Okay, I am gonna place you on probation, but they'll be non-reporting. Under non-reporting probation for 6 months. The only requirement is that you maintain your employment and that you complete the anger management course, okay?
Thank you, Your Honor.
You can get that information from your probation officer, who It's just so happens to be sitting here. And so you can get the information about where you can do that. I will not order you to do any testing at this time because you are non-reporting. There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed, and I'm assessing a fine of $180, okay? You can make monthly payments on that, or you can pay it all in full, it's up to you. Do you have any questions at this time?
At this time, does agent want him to go down and to,
Orders appointment set up, so we can sign some paperwork.
so he'll go report to the probation department right now.
Thank you.
You are all set for now. Did I see Mr. Palmer is here, and then Mr. Johnson, you're here on who? Oh, Javier, is he here?
Yes, ma'am.
Okay, on the record of the matter of the state of Michigan versus Javier Lujan, 25-02193, appearance, please.
Haley Fortuna Gill on behalf of the people.
Good morning, man. Please, honorable court, Kareem Johnson, on behalf of defendant, approach to my immediate right.
Mr. Lujan is scheduled for a preliminary examination on assault with a dangerous weapon next week on the 14th at 9 a.m. So we're going to be running an exam next week.
Yes, Your Honor. An offer was made to my client. I've explained it off to my client, but we're asking the court to set this matter for preliminary examination.
The offer that the people have extended on this is a DV second, dismissing the remainder. The offer would remain open until the preliminary examination.
We will continue to examine at this time, see you in person at 9 a.m. next week. Do you have any questions for the court? Any additional matters for the record?
No, Your Honor, thank you.
Nothing, Your Honor. Okay. Where did Mr. Palmer just go?
Oh, I'm right.
Oh, I can't see.
I'm
that.
hiding behind you.
On the record in the matter of the state of Michigan versus Hop Yen 22-03449, 23-00102, and 25. I mean, that's it. I don't know if you can see him now. I don't know what happened. He's in a hospital.
He's in Kalamazoo Psychiatric Hospital, Judge. For what it's worth, I did try to call them yesterday. I kind of played phone tag to see if I could verify that they were going to be on. I never actually heard back.
He has been on. I had to put him in the waiting room because he was making some outbursts. So, I wasn't sure who he was talking to or what he was saying. So I removed him so I can carry on the proceedings. It appears that they're still there. However, it is muted and the video is off. So I'm not able to confirm if he's here. And this was a competency?
Yes.
Okay, and you can waive his appearance for this purpose if you like. He is there. Okay. Present. Okay, and I do have a report here that was sent from the Department of Health and Human Services Center for Forensic Psychiatry on the 30th of July. Both parties got a copy of that.
Yes, Your Honor.
Yes, ma'am.
Okay, the conclusion is that the opinion is that he is incompetent to stand trial and likely to attain competence. Any reason to object to the body or the conclusion of the report?
No, Your Honor.
Judge, I'm not objecting to the finding, and I guess I'm not objecting to the entry of the report. I am a little bit baffled about how they think he's going to be restorable within the time limit, given that he's lived in adult foster care homes and psychiatric hospitals back and forth since 1987. And as the report indicates, he has a chronic history of mental illness. They report that multiple times. He's previously been found incompetent in other matters. I would also just note for the court that these matters, the underlying matters for on both of these cases are essentially while he's in the middle of psychiatric outbreaks. So, and one of them occurred in a psychiatric facility. Actually, they both did. How we think we're going to get incompetent within 15 months is beyond me, but if that's what the report says, I guess that's where we're at now.
Okay. I had to disadvise.
Who were you talking to, sir? I think he's talking to someone else. I don't think he was talking to us. Okay. I will adopt the report without objection and incorporate into the court record. He will be ordered to undergo treatment to see if he can be restored within the statute of the time frame. We'll see what happens. Okay, let's see. I have 2 files. So we'll set it for a review, internal review date. Any additional matters for the record?
Nothing, Your Honor.
No, Your Honor.
You're all set. Thank you.
Thank you, Mandel.
I'm sorry. The order. Oh, was there one in both files? I don't think there was an order in there I should have signed. I didn't know you was doing this today. What's happening? What's this? I just wasn't aware he was an MDOC.
Oh, okay.
Morning. Ms. Sutter, is here for Mr. Washington?
Yes, I am.
On the record in the matter of the state of Michigan versus Marquise Washington, 24-03116.
Haley Fortuna Gale on behalf of the people. Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Washington, who's joining us via Zoom.
Okay, today was the day that was scheduled for sentencing. I have to refresh my recollection, and now it all comes back. Got it. Okay. We have an updated report from probation. That's not, did you get a copy of that, I should say?
I received a report on 7/11. I think that indicates they no longer find him a patient.
That's the report that I have as well.
Yeah, sure, I got that.
You can make allocation.
Thank you, Your Honor. Obviously, there's been some unfortunate decisions made leading up to today's hearing. Mr. Washington is fully acknowledging of that, and he would like to make a statement or apology to the court in a moment. In regards to the sentencing here, understanding the recommendation has changed. When looking at the first recommendation here, they did note during his conversation that Mr. Washington does take accountability for the poor decisions that led to these charges being issued. He admits that he was drinking that night. He was in possession of a phone while driving. He was making some very foolish, quite dangerous decisions, and those have had some very serious ramifications for him as well as the other people involved in this case. He admits it was stupid. He's continued to make decisions since then. He advises me, and I believe he advises officer as well, that he's not an individual who drinks often, but clearly when he does choose to drink, he's not prepared to make the best decisions. He knows that. He's learned that in any way a person possibly can learn that. To give some background on him, what was going on around the time of this original incident, he was dealing with a lot of stress at home. Very, very sick. They've been in and out of care at the Grand Rapids Children's Hospital. That's something he's been consistently dealing with, traveling when he was in Florida, back up to Michigan twice a month for that. Child is improving now, which is good news, but it's still something he's dealing with. But the worst of that illness was in the fall of last year, and in October in particular, dealing with gastroenterologists, endocrinologists, anything he can to make his 3-year-old son well again. And he wasn't handling that stress well last October, which led to the incidents here. I understand and fully acknowledge that the court on more probation is probably deeming him to be a good candidate for probation at this time, given what happened in March. And I think he knows that as well. Given that, Your Honor, we are accepting that the court is going to issue a jail sentence here. I would ask the court to consider limiting the jail sentence to something like 93 days or 90 to 100 days, something short of the 365. He has already served 33 days jail at the minimum, as far as I've been able to calculate from numbers given to me by the Ingham County Jail. He also does still have 2 young children who entirely rely upon him for both financial and medical care. As I said, he is still dealing with his child being in and out of care at the Grand Rapids Children's Hospital. He does have employment waiting for him once he is completed and his sentence here. He does know he has an ongoing misdemeanor case here that he's fully prepared to stay in Michigan until the end of that case, through whatever resolution results there, and has work waiting for him once he's wrapped everything up. Once he does that, he is planning on moving his family full-time to Florida, but he knows until he's done here with this court, he's staying in Michigan absolutely to take accountability for anything that's previously happened. So my request, to summarize, Your Honor, is to ask the court to limit any kind of jail sentence between 90 and 100 days. Thank you.
Right, one statement.
He did last night, Mr. Washington. This is the time for you to make any kind of statement to the court you'd like to.
I just want to apologize to Judge Simmons for lying to your face. I was 100% wrong. That was probably the dumbest decision I ever made. Sitting here trying to play in your face in court. I'm taking full accountability. And yeah, I promise from here on out to be truthful and 100% honest. Since I've been incarcerated though, I just want to state it probably doesn't matter to you, but I have lost my car with all of our belongings in it. So we have no way to get back to Florida even. My son has no way to get to the medical appointments in Grand Rapids because they rely on me to do it. My girl and the kids have been living in the hotel. We've been running low on money, so I don't know how much longer that's gonna even last. But I'm definitely taking full accountability for lying to you. lying to my lawyer, the probation officer. That was wrong. I don't even know why I even did that.
Thank you, and thank you for taking the opportunity to address the court. The things that you're undergoing or experiencing now, which include the loss of your vehicle, the mounting bills, the inability to provide transportation and support for your child who's facing some medical issues, that is completely attributed to your own actions. You did that to yourself. You put your family in a precarious situation. You sacrificed your freedom. You sacrificed your ability to be there with your family, your ability to work, and your ability to maintain your possessions when you first committed the actions that brought you before the court, and then after coming before the court on that, for whatever reason, thought it would be in your benefit to just lie as if the court was supposed to follow along with the stupidity that and the game that you thought you were running around in my courtroom. And that was back in March. I issued a bench warrant in April when you failed to appear, because when you appeared before me in March, and you gave me the story that you were in Florida, and I questioned that you were in Florida, and I told you to step outside so that I could see the address on the home. And you gave me a story about the address not going to be there. And then you stepped outside only for me to see in March, bare trees and no palm trees and no sun. And even then, you didn't believe it was time to face the truth. But you doubled down and became belligerent. That to me is a deep core issue. And I am happy to hear that you are ready to tell the truth and to move forward in a different light. But I hope it's because deep down you know that you need to make a serious change in your life, because you are on a dangerous path. I've also learned some other information in dealing with this about you, and that you have a history, sir, from what I hear, of using your other family members' names who has the same name as yours. That's what I was advised, and including your dad and your brother who's a police officer here at the Lansing Police Department. So if the history that you have is lying after you commit actions, you're in trouble, and you're going to find yourself behind bars for much longer than 365, or even worse. The actions that you committed to get you before the court, you should be lucky and blessed and thankful to the heavens that you are still alive. You could have taken your own life. You could have taken the life of someone else, and then to come before the court several months later, you never even turned yourself in. So everybody's sorry and everybody's remorseful and everybody feels a certain way after they're caught. You didn't have a life-changing moment after our interaction in March and then say, let me come to court in April like she ordered me to do in person. Not only did you not come to court in April, you didn't come in May, you didn't come in June, and you didn't come until you had another case and you were picked up in custody. You had to be remanded. We had to hold you in the jail just so I can get you here today. And so to tell me about all these responsibilities that you have, and that you now conveniently will have a job waiting for you when you get out. Where were you working before you got arrested?
Well, I was working in Florida with my dad. He owns a business. He owns a painting company. When I was here, I wasn't working. My girl was working at McDonald's on Johnny and Dunkel.
I didn't ask you where your girl worked. Your girl's not before court. You're a man. You're a man. Don't tell me where your girl works.
Yes, ma'am.
If a man don't work, he shouldn't eat. You ain't got no business relying on some woman's job. Where were you working before you got picked up and brought into custody?
I wasn't working.
And now conveniently you have a job waiting for you. A job where?
I have a job waiting for me in Florida, like the same job that I've been working. But I can't even go back there. We don't have there's no way to go back.
So you don't, it sounds like you don't have a job waiting for you.
The job was M&W painting and near Clearwater, I believe specifically. He was gonna have to be seeking different employment up here while his other case is still waiting to be resolved.
Yes, I was gonna just stay here and find work here while we get to the October case. That's what I was telling her. But I for sure have a real job when I go back down there. But I told her when I get out, I'm gonna just stay in Michigan and find work here until the other case gets over with. Cause I never had plans on
You
staying.
mean you're just gonna stay in Michigan? That's an order, isn't it? You have an order to
Yes.
stay in Michigan. It's not an option for you to go to Florida. What are you talking about? You're very delusional. The sentence of the court is 180 days. I'll give you credit for the time served. You're not getting any additional earned early release or GPS tether release. There's also a whopping amount of OWI cost recovery that you're gonna need to pay when you get out. You owe the Lansing Police Department $1,646.61 for responding to this. It's a $75 crime victim rights fee that will be assessed plus a $50 state minimum cost. Do you have any questions for the court at this time?
So I have to do 5 months with no EER or nothing?
That's correct.
That was exactly what I said. Any other questions?
No, ma'am.
Okay, you're all set. What was the credit you said?
33. I believe it was 3 from October and 30 from July 9th.
Thank you.
Your Honor.
Yeah, you same to you. Thank you. For the record, in the matter. Oh, is Mr. Starks supposed to be here for something? No. Mr. Starks is not here. Let me see. Mr. Green, you're here on Precious Taylor?
That is correct, Your
Is
Honor.
Precious Taylor here?
Here.
Precious Taylor take care of your fingerprints? I asked a question. Did Precious Taylor take care of her fingerprints?
No, she did not.
Okay, Precious Taylor needs to take care of fingerprints before I can call her case. And then this was Mr. Shepherd. Are you ready on Mr. Shepherd?
People are ready, Your Honor.
I am as well.
On the record in the matter of the state of Michigan versus Nicholas Shepherd, 25-01414. Appearance, please.
Haley Fortuna Gill on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Shepherd. He is present to my left in the jury box.
Mr. Shepherd was scheduled today for a preliminary examination. And this is for domestic violence. Third. Are we running an exam today?
No, Your Honor, the people do not have the necessary witnesses at this time to proceed. The victim, I haven't been able to get in contact with her. The officer, I was made aware from Mr. Austin that there was an officer present on this case. However, after APA Tepper went and looked for that officer, we were unable to locate that officer, so we are unable to proceed with this exam.
Who was the officer you were looking for?
I don't know who the officer is that actually showed up.
And I don't know either. He didn't
Who
identify.
did you
his name.
subpoena?
Several people were subpoenaed, Your Honor. Let me see. Uh, Officer Newton. Also, I was mistaken. He was the only one subpoenaed. I have Officer Kennedy here as well, but she was not subpoenaed, so.
Mr. Austin.
Thank you, Your Honor. I would note this is the second time the complaining witness has failed to appear in this matter. I know the last time the people did not have any direct communication with her. Apparently they spoke with her father, but apparently she is not here again today. Mr. Shepherd is on dead time because of his parole status. So given that, Your Honor, I would ask the court to dismiss the matter against Mr. Shepherd at this time.
Looking in the file, we were aware that he was an MDOC because my note from May 30th says that he was an MDOC as of the 29th.
Yes, he was taken in MDOC custody on the parole matter, I think the night before the originally scheduled prelim when we were here. A day or two before.
Okay. All right, well, it's unfortunate that the officer failed to appear after we've incurred expense of bringing someone here from the Department of Corrections. The motion to dismiss without prejudice is granted. We'll get him a copy of dismissal in just a moment. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
I have nothing additional on behalf of Mr. Shepherd, Your Honor. Thank you.
Thank you. Green is there. Okay. On the record in the matter of the state of Michigan versus Precious Taylor. This is 25-00-744. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Thank you, Madam Administrator. We have Defendant Pressure Taylor standing to my right.
Okay, she's taking care of her fingerprint this time.
That is correct.
Okay, today was the date scheduled for a preliminary examination for carrying concealed weapon. How are we proceeding?
Your Honor, at this time, the people are prepared to unconditionally waive the preliminary examination. I do believe defense is going to be the same.
That is correct.
Was there an offer?
There was no offer on this. Negotiations, of course, will continue in circuit court.
Okay, Ms. Taylor, you understand that you're being charged with a felony carrying concealed weapon.
Yes.
You understand that you have the right to hold a preliminary examination here in the district court where you would require the prosecutor to establish that they have sufficient probable cause that the felony was committed and then probable cause sufficient to charge you as the person who committed the felony.
Yes.
You want to unconditionally waive your exam? Anyone threatening you to get you to waive your examination?
No.
Has there been any promises extended to you to get you to waive?
No.
And that's your signature here, ma'am?
Yes.
Your bind over date is August 20th. So August 20th is the date that the circuit court gets to file from the district court, not a date that you must appear in court, okay? Your next court date will be a pre-trial at the circuit court. Your attorney will be made aware of that, okay?
Yes.
We have an address for you on Wacosta Drive in
Yes.
Fowler. That's still accurate? And your phone number has not changed since you were arraigned either, is that correct?
No.
Okay, bond will continue. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Not for the defense, Your Honor.
Thank you. You're all set. And then I think if Mr. Search was on the record over there. They have a packed house over there, actually. Let's see. Ma'am, what's your name? Okay, got it. On the record in the matter of Johnny Davison versus Shamika Barney, 25-00019. What's your name, ma'am?
Shamika Barney.
Your name, sir?
John Davidson.
Okay, we received notice of a stay for bankruptcy on this.
Yes.
Yes, yeah, I see, I entered an order, the case is stayed pending bankruptcy proceedings. So we're unable to proceed because there's a bankruptcy proceeding.
It's already been,
Yeah.
disregard, it's been,
Discharged.
discharged, so everything's discharged, so he won't,
Yeah.
my personal assets is discharged.
We're not able to proceed.
You can't get anything in this.
And so there, I signed an order, I think yesterday on that, or 2 days ago, the clerk's office notified me that the case needed to be stayed.
Okay. So what do I need?
That means that we can't proceed because she filed a bankruptcy. Both cases, the counterclaim are stayed, so you're all set.
So
What
does-
about my counterclaim that I have?
Let's counterclaim is stayed as well,
Okay.
Thank you.
Fine, thank you.
What does stay mean?
That means they can't move.
Until when?
And never.
I don't know what's going on with her Western District bankruptcy case. I just got a notice that the case was stayed in bankruptcy. That's
Everything was discharged.
I don't have that. I have a notice that says this case has been stayed in bankruptcy.
And he was gonna receive a letter in the mail from my attorney. She just mailed it Monday, so she said he probably wouldn't get it before court anyway, so.
Yeah, so you can go down to the clerk's office and get a copy of that.
Have a great day.
Have a good one.
Thank you.
Good morning, how are you?
My apologies, I was next door. running-
No worries, I saw you were over there, y'all had a full house over there. Let's see, Milner, are we, gonna run an exam on that?
That is correct, Your Honor.
Okay, we can have Milner brought up. Okay. Oh, she didn't know who we didn't see him too. Okay, on the record, in the matter or matters of the state of Michigan versus Charles Milner, second, 25-01676. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender here on behalf of Mr. Milner. He's president counsel table. He's seated to my right.
Okay, today was the date that was scheduled for preliminary examination on weapons charges. Are we ready to proceed?
Yes, Your Honor. The people are prepared to proceed before the preliminary exam starts. If I could approach with the judgment of sentence.
Yeah.
Certified. Let the record reflect I am showing the certified judgment of sentence to counsel.
Okay, any other preliminary matters?
Not on behalf of the people, Your Honor.
I would just request the sequestration order, Your Honor. Thank you.
Sequestration is granted. How many witnesses do you have?
2, Your Honor.
Okay. Are they both officers?
That is correct.
Unless there's any other preliminary matters, you can call your witness.
The people call Trooper Calvin Harshman.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can be seated. State your first and last name and then spell both.
Yes, Calvin Harshman, CALVIN, HARSHMAN.
Okay, thank you, Your Honor. Trooper Harshman, tell me about what you do for a living.
I'm employed by the state police. I've been here for just over 7 years.
Okay. And were you working as a state trooper on June 5th, 2025?
Yes, ma'am.
Okay. And are you familiar at all with Charles Milner?
Yes, ma'am.
Did you have an interaction with him on June 5th of 2025?
Yes, ma'am.
Okay, do you see him here today in the courtroom?
Objection, Your Honor, like a foundation.
Your Honor, I believe that Trooper Harshman just testified that he had an interaction with Mr. Milner on June 5th of 2025, and now I'm asking him if he sees him in the courtroom.
What further foundation are you looking for, sir?
My apologies, Your Honor. Yeah, I don't understand the context as to what would have prompted this encounter in the first place, or what his prior foundation would be in terms of identification or anything else. So
that's valid.
Okay.
Objections sustained.
I'll ask more questions. So, Trooper Harshman, please tell me a bit about your interaction with Mr. Milner on June 5th, 2025.
I conducted a traffic stop, and the driver was later identified as Charles.
Okay, and what prompted the traffic stop?
The vehicle had a registration plate that was invalid, and the vehicle was crossing over the center line multiple times.
Okay, and when you say the registration plate was invalid, was it expired?
I believe it was so expired, it just wasn't in the system of the SOS anymore.
Okay,
So it wasn't in the system for.
Correct, ma'am, of SOS anymore, Secretary of State.
okay. So when you ran the plate, you didn't find any registration records at all?
Correct.
Okay.
It normally shows previous registration, but it wasn't associated to any vehicle at the time.
Okay. So then when you found out that the plate, that there was no registration for that vehicle, what did you do next?
Conducted a traffic stop, on Pennsylvania and pulled onto the side street there, which I believe is Irvington.
Okay, so you said Pennsylvania, do you know the cross streets?
It would have been Pennsylvania heading southbound over the bridge. I'm not familiar with all the streets that are there.
Okay, but Pennsylvania, are you sure that that's in, is that in Lansing?
Yes, ma'am.
And is that in Ingham County?
Yes, ma'am.
Okay. So tell me more about your, when you said you initiated the traffic stop, what did that entail?
I made contact with the driver and advised him why we were stopping the vehicle. Asked him to provide a driver's license, and he advised he did not have.
Okay, and did you tell him that you were stopping the vehicle because of the registration?
Your Honor, I'm going to object that the trooper's statements in this context would be hearsay.
Did you want to respond to the hearsay objection?
Yes, Your Honor. It's not being offered for the truth of the matter asserted. It's just being offered for the effect on the listener as far as what the trooper said to the driver.
Objection overruled.
Yes, I advised him to stop him for the registration plate when used.
Okay. And then what happened next after he informed you that he did not have a driver's license?
I asked him to exit the vehicle. He initially did not comply. I asked him a second time to exit the vehicle. He did not comply the second time. I asked him if he had any, I said, do you have anything on you? Asked him if he had any weapons or anything like that. He said he had a pocket
Again,
knife.
Your Honor, I'll object on the grounds that the trooper's statements would be hearsay to the driver. Thank you.
Your Honor, the trooper's questions are, again, just being offered for the effect on the listener. We're understanding why the defendant responded in the way that he did, which would be admission by party opponent.
Objections overruled.
Thank you.
Driver stated that he had a pocket knife and he pulled that out of his right pants pocket. He eventually exited the vehicle. My partner, who was on the passenger side, asked him if he had any firearms. He did not answer the question. When he exited the vehicle, I placed him in handcuffs. My partner conducted a search and located a firearm in his front pants pocket.
Okay, so there was, just so I understand, there was a pocket knife that was recovered?
Wasn't recovered. He had it in his pocket. He took it out.
Okay, and then there was a pistol that your partner later found.
Yes, ma'am.
And what is your partner's name?
Sergeant Williams.
Okay. And then what happened next?
Secured the driver, finished a search on him. I went back to the vehicle, checked his license status, see if he had warrants or anything like that. Ran the VIN on the vehicle, and then my partner tried to secure the firearm. Once that was secured, I had the front seat passenger exit the vehicle.
Okay. And who was that front seat passenger?
I do not remember
Okay.
her name. It was
No
his
problem.
sister.
And then the driver, who was the driver?
Charles Milner.
Okay, and do you see him here today?
Yes, ma'am.
Can you point him out and describe an article of clothing that he's wearing?
Yes, ma'am. He is seated to your right, to my left, wearing a blue shirt, sitting in the defendant seat.
Okay, Your Honor, at this time, I would like the record to reflect that the witness, Trooper Harshman, has identified the defendant as Charles Milner.
Any objection to identification?
Thank you, Your Honor. Yes, objection on grounds of lack of foundation. Thank you.
Objection is I'm sorry, identification is noted.
Thank you.
Objections overruled.
Thank you, Your Honor. No further questions for this witness.
Cross-exam.
Thank you, Your Honor. So in terms of the registration, what was the issue with the registration again?
The vehicle is unregistered.
And how do you obtain that information?
Through the Secretary of State and our lien app.
Okay. And what approximate time was this traffic stop initiated?
I'm not sure. It was early afternoon. I'm not sure the exact time.
And how many people were in the vehicle at the time?
3.
And where were these individuals located inside the vehicle?
Mr. Milner was in the driver's seat. I believe it was his sister was in the front passenger seat, and then there was a little child in the back.
And what were the lighting conditions like when you first approached the vehicle?
Daylight.
And when you first approached the vehicle, was there anything in plain view that would have been suspicious to you?
No, sir.
So you didn't see any firearms when you first approached the vehicle, correct?
Correct.
And you didn't immediately recognize the driver as Charles Milner, correct?
Correct.
When you asked the driver for identification and other types of paperwork, the driver complied with your request, correct?
We say he didn't have a license.
Okay. Were you ultimately able to get some type of registration or insurance for the vehicle?
I do not recall if he had any paperwork for the vehicle.
Approximately how long did your interactions with Mr. Milner last?
Our initial interaction, 3 minutes.
And just to clarify, you did not search Mr. Milner. That was another trooper, correct?
Yes, sir.
All right. And which trooper was that?
That was Sergeant Scott Williams.
Sergeant Scott Williams. So, did you search the vehicle at any point?
Yes, sir.
All right. At what point did you start searching the vehicle?
After my partner secured the first firearm and I had the passenger and the child exit the vehicle, I conducted a search of the vehicle.
Okay. And in terms of your observations, how was the alleged firearm disposed of?
Just the first one was in his pocket.
Okay, and what did you see happen with this alleged firearm?
What? I guess my partner tried to secure it by taking the rounds out of it.
Did you observe that yourself, or are you just speculating?
No, I observed him trying to take the rounds out.
Okay. And what did you observe in terms of what happened with the firearm after that?
After he took the rounds out, I placed it in the trunk of our vehicle.
Okay. Was the item properly secured in some type of bag, some evidence bag, or anything along those lines? Did you observe that?
I don't recall exactly. Normally, I have a Pelican case that I place firearms in.
Okay. Was the trooper wearing gloves or anything along those lines when the trooper's handling the fire?
I don't remember now.
And so, where were you positioned when Mr. Milner was searched?
Behind him, I'll put him in handcuffs and then part of the search.
So, how did your partner search him based on your regulations?
I guess say reaching for his pockets.
Okay. And when you first approached the vehicle, there were no furtive gestures or anything along those lines, correct?
I didn't see him doing anything, no.
And again, there's nothing in plain view when you first approach it, correct?
Correct.
Okay. did either you or Sergeant Scott Williams, did anyone obtain permission from Mr. Milner or anybody in the vehicle?
I don't believe so, no.
Okay. So in terms of searching the vehicle, searching the vehicle, what was the basis for the search?
Probable cause for CCW.
What does probable cause mean to you?
Objection, Your Honor. He's asking for a legal conclusion from his witness.
You want to respond?
Well, I'm just asking based on his experience and training and his knowledge, what does that term mean to him? I'm not asking for him to draw any legal conclusions. He just testified it was probable cause. So what does that mean?
I agree. Objections overruled.
Thank you, Your Honor.
That an individual has illegally concealed a firearm.
Okay. But I was asking you about the vehicle.
Can you ask the question again? Sorry.
Sure, no problem. What was the reason to search the vehicle?
Probable cause to believe the driver committed the crime of CCW. The vehicle.
Clarify, you didn't observe any firearms in the vehicle when you first approached, correct?
Correct.
And you didn't observe the firearm being recovered. That was another trooper, correct?
I observed it being recovered, but yes, other trooper recovered it.
And nothing further, Your Honor. Thank you.
Yes, Your Honor. On June 5th of 2025, when you conducted a traffic stop on Charles Milner, were you in a fully marked police vehicle at that time?
Yes, ma'am.
Okay, and were you wearing your fully marked police uniform like you are today?
Yes, ma'am.
Okay, and was Mr. Milner being placed under arrest during the traffic stop?
Yes, ma'am.
And what was that for?
CCW, prohibited person, felony firearm.
Okay, and just to clarify, when you first started the traffic stop, did Mr. Milner disclose that he didn't have his driver's license?
Yes, ma'am.
No, did he just not have it on his person, or did he not have one at all? Do you know?
He did not have a valid license.
Oh, thank you. No further questions. May this witness be excused?
Yes, thank you, Super Harsher. Can you call your next witness?
Yes, Your Honor. The people called Sergeant Scott Williams.
Yes.
Thank you. Thank you so much. We're gonna take a stand.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth on the penalty of perjury. Thank you. You can state your first and last name and spell both.
Sergeant Scott Williams, SCOTT WILLIAMS.
Proceed, counsel.
Thank you, Your Honor. Sergeant Williams, can you tell me what you do for a living?
Currently, I am a sergeant with Michigan State Police and I'm assigned to the Security Service Partnership.
Okay, and how long have you worked as a police officer?
I've been a state trooper for 10 years. I've served as a sergeant of the Security Service Partnership for the last 2.
Okay, so 12 years total.
Or 10 years total, sorry. The last 2 have been.
Oh, got it. Okay, 10 total. Perfect, thank you. And were you working as a sergeant on June 5th of 2025?
Yes, sir.
And did you have any interactions with Charles Milner?
I did.
Can you tell me about that interaction?
I was riding passenger, Trooper Harshman was the driver. We initiated a traffic stop.
Can you tell me why you initiated a traffic stop?
When I ran lean, the vehicle came back unregistered.
Okay.
And then Trooper Harshman also saw lane use violation.
Okay.
Activated emergency lights, initiated traffic stop, came to a stop. We made an approach. Trooper Harshman as the driver makes driver side approach. Since I'm riding passenger, I made passenger side approach.
Okay.
There was a male driver, later identified as Mr. Miller, the female passenger.
Okay.
Trooper Harshman was speaking with him, asking him for his typical identification, driver's license, registration, insurance. He informed me he did not have a driver's license, so he requested he get out of the vehicle. From my point of view.
Hold on 1 second. When you say he requested to get out of the vehicle, are you talking about Trooper Harshman?
Yes.
Okay, and the other he here is Charles Miller.
Correct. Trooper Harshman instructed Charles Miller to get out.
Perfect. And so what happened after that?
So prior to him, right when he asked that prior to him getting out, I did notice a pocket knife in his pocket, right pocket from my point of view from the passenger side.
You said a pocket knife?
Correct. Yes, ma'am. Pocket knife. I informed Trooper Harshman he had a pocket knife, and I told Mr. Miller to take it out, which he complied, and he pulled the pocket knife out and put it in.
Okay, do you recall which pocket it was?
I believe it was right front hand side.
Right, that would make sense if you were on the passenger side. Okay. So what happened after you put the knife in the center console?
Trooper Harshman instructed him to get out of the vehicle. He was basically, in my words, stalling, wasn't complying, wasn't getting out of the vehicle. Continued stalling, told him to get out, and continued reaching around for belongings that we didn't even need anymore. I think he was still looking for his information insurance, which I can't remember exactly what it was, but we're like, hey, we don't need that anymore.
When we say reaching around, do you mean, how do you mean? Can you describe that a little bit
So
more?
he was looking around, looking for documents, and then he kept touching his pocket. He kept reaching in his pocket. And at that point, based on my training experience of seizing hundreds of guns, I was like, okay, he's acting very suspicious towards that right pocket. And that's when I leaned in and I said, hey, is there anything in this vehicle you know about? Mr. Miller gave me a blank stare, which based on my training experience, normally means there is something in that vehicle. So I asked him the second question of, is there a gun in this car? And he continued to give me that same blank stare.
So you did not respond?
Correct. Based on my training experience of just on SCP alone, we've seized several hundred guns in the last 2 years. I had a good feeling there's probably a gun in the car. And I told Trooper Harshman we needed him out of the vehicle. And that's when he instructed him to open the door.
Okay, and what happened after Mr. Milner was out of the vehicle?
He was detained, and then when I walked over there, firearm was secured from his right front hand side.
Did you secure that firearm? Okay, and it was in that right pocket?
Yes.
Okay. What'd you do after you secured that firearm?
He was taken back to the front of the vehicle. I secured the first firearm, and then Trooper Harshman remade contact with the front passenger. And once she was out of the vehicle, we conducted a search of the vehicle. And then that's when the second firearm was located. That was located by Trooper.
Objection, Your Honor. Purely speculation. This officer, sergeant, cannot testify to what his under trooper was doing. And further, you already heard from the previous witness on this issue, and there's no testimony about this whatsoever. So respectfully, this is purely speculative on the sergeant's part.
Did you want to respond to the speculation objection?
Yes, Your Honor, I do believe that Sergeant Williams is testifying for what he saw.
Well, let's confirm that.
Yeah, I'd love to. Sergeant Williams, did you see Trooper Harshman search the vehicle?
Yes, I was standing back at the front of our patrol vehicles, Mr. Miller, while he was conducting the search.
Objections overruled.
Thank you, Your Honor. So did you see Trooper Harshman locate that gun?
I observed Trooper Harshman get out of the vehicle from searching it and walk back toward the second.
Walks back where?
Walk back towards me in the patrol vehicle with the second fire.
Thank you.
And so what happened after that second firearm was located?
Typical business, we secure both in our property box, put it in the vehicle. At that point, he informed me that the vehicle was good, and the search was complete. And then we placed Mr. Miller in the front seat of our patrol car and transported him to Mississippi.
Okay. Can you tell me, do you remember what cross streets you were at when this traffic stop occurred?
I can't remember the exact street we're on. It was right off, it was a side street right off Pennsylvania.
Okay, and is that in Lansing, Michigan, Ingham County?
Yes.
1 second. Did the defendant make any phone calls in your presence?
Yes, ma'am.
Was anything of particular interest said during that phone call?
Yes, ma'am. I believe it was prior to us departing to the jail. We're still parked at the stop. He was in the front passenger seat on the phone call with Big Bro 3 was the title. And
You said Big Bro 3?
Big Bro 3 was the contact name. And while it was on speakerphone, we made a statement of bro uncooked. They got 2 of them, which based on my training experience, I assume was the 2 firearms.
Okay, can you turn your voice this way? Because I have a
Yes,
fan going, and so I heard you say, he said, bro, I'm cooked, and then what?
I said, bro, I'm cooked. They took 2 of them off of me,
Okay.
which based on my training experience, I assumed to be the 2 firearms that was secured from the vehicle.
Okay, thank you.
Subject.
And at this time, were you wearing your fully marked police uniform like you're wearing today?
Yes, ma'am.
And were you in a fully marked police vehicle?
That's right.
No further questions for this witness at this time.
Cross exam.
Thank you, Your Honor. Sergeant, what time did you encounter Mr. Miller on either?
I do not recall the exact time. I know it was daylight out. I would say probably later afternoon, early evening.
Okay. And approximately how long did this interaction occur?
From start to finish, I would say probably 45 minutes tops.
Okay. Where's the location of the traffic stop?
It was off of Pennsylvania Avenue and south of the bridge. I can't remember the exact side street that he turned on.
Okay. And did you first approach the vehicle or was that Trooper Hart?
Probably about the same time, to be honest.
Okay. And you approach on the passenger side, what side did you approach?
So I made a fat passenger side approach.
Okay. So walk us through what happened after Trooper Harshman asked Mr. Miller to exit the vehicle.
To me, it appeared that he was stalling. He did not comply. He did not get out of the vehicle when asked. Continued kind of looking around, reaching around. Was almost trying to, like I said, stall to knock it out of the vehicle.
So you testified earlier that anytime someone gives you a blank stare, that's indicative to you that there's some type of contraband in the vehicle. Is that true?
Not necessarily. With the totality of the circumstances and everything else, then yes, I believe it was the firearm in the vehicle with what I saw in totality, but not just the blank stare itself.
Well, but there are no firearms in plain view when you first approached the vehicle, correct?
Correct.
And you did not observe any firearms on Mr. Milner when you first approached him, correct?
No.
And you did not observe any firearms on any of the passengers when you first approached them, correct?
Correct.
And the pretext of the stop was a moving violation, correct? Something with the registration and swerving of the vehicle, correct?
Yes, sir.
So you didn't observe any furtive gestures or anything along those lines when you first approached the vehicle, correct?
As far as firearms, no.
Okay. Well, you didn't observe anything that would suggest to you that they were trying to hide contraband or anything like that when you first approached the vehicle, correct?
Are you talking as I'm walking up to the stop?
Yes.
No.
Yes. No. And what was the lighting like inside the vehicle itself? You see clearly?
No, absolutely. It was light up.
Okay. So if your reports reflected that it was sometime around 8 o'clock in the evening, are your reports wrong?
No, I would say it's fine.
Okay, so when Trooper Harshman testified it was in the early afternoon, was he just wrong?
Whatever the report says is going to be correct.
Okay. So where was this second alleged firearm located?
I don't know. I did not search the vehicle.
Right. And what did you help dispose of you found the first one, correct?
I took it off Mr. Miller's pocket.
Describe to us how that search happened.
I reached into his pocket and pulled the firearm out.
Okay, so you didn't do a Terry pat?
He was in custody for the no operative license.
And your testimony is that you directly got it from his person, correct?
Yes, sir.
Right. And what pocket again was this particular item found in the right front? And what type of vehicle was this?
I don't recall. It's a sedan, vehicle car.
Okay. Approximately, and there were multiple people in the vehicle itself.
There's two.
The two additional passengers or just two people?
Two people total, Mr. Miller and one front passenger.
So there's nobody in the back of the vehicle?
Correct.
Okay. And in terms of the vehicle itself, did you conduct what we'd call an inventory search?
I don't recall. I did not conduct the search, so that would be something that you were.
Okay.
Now I know obviously the probable cause we would not necessarily need a search.
So what does probable cause mean?
Probable cause search vehicle of crimes we committed, in fact, that we secured a firearm off as persons. So it's probable cause search vehicle that continued further crime that have been committed and further firearms inside the vehicle.
Now, you're a sergeant, correct?
Yes, sir.
So you basically have rank.
I do.
So were you directing the search of the vehicle?
I wasn't directing anything. I was assisting him on the stop and used his investigation and assisting him with it.
Okay. You never searched the vehicle at all, correct? You were in the back seat with Mr. Miller, correct?
I was standing at the front of the patrol vehicle with Mr. Miller.
Okay. So you weren't even inside the vehicle when he allegedly made that phone call, correct?
No, I was. I was sitting in the front passenger seat.
Okay. And do you know who the source or the other person was on the other end of the call?
Just title of the name is Big Bro 3, so no idea.
And how were the firearms handled when they were recovered?
These are the ones that we seized them.
Yeah.
So we have a property box in the back of our car. So once they're secured, we obviously clear them to make sure that there's no rounds still left in them. They're safe. They're placed in that box and then they're taken to the Lansing State Police Post and placed in the property room.
Did you ever handle any of these alleged firearms?
Yes. Once they were seized, yeah, I secured them and placed them in the property.
You have gloves on you when you're handling them?
Yes, we always have both.
And to the best of your knowledge, were either of these firearms ever swabbed for DNA or tested for drugs?
I do not recall if they were.
Good. To the best of your knowledge, where was the second firearm allegedly found?
From what I was informed by Trooper Hirschman, that's all I can go after.
So you don't know?
I did not see him where he took the firearm from. I just saw him exit the back seat with the firearm.
Okay. And in terms of, but was Trooper, in terms of the patrol car itself, who was operating the patrol car?
Trooper Hirschman.
Trooper Hirschman. Okay. So you're a passenger in the vehicle?
Yes, sir.
Oh, thank you. Nothing further, Your Honor. Thank you.
Any redirect?
Yes, Your Honor, excuse me. When you were conducting this search, or when you were conducting this traffic stop, were only those two guns secured?
Those are the only two firearms located.
Okay. And was anything else secured?
Not that I recall.
Okay, was the pocket knife?
No.
Nothing further.
Thank you. May this witness be excused?
Yes, Your Honor, please.
Thank you, Sergeant Williams. There is a sequestration order, so you're not allowed to discuss your testimony with any other witness.
Yes, ma'am.
Thank you. Any additional witnesses for the people?
No, Your Honor.
Yes, to the judge calling witnesses.
No, Your Honor, thank you.
Your Honor. Today, Charles Milner is being charged with 2 counts of carrying a concealed weapon, 2 counts of possession of a firearm from a prohibited person, and 2 counts of felony firearm to go along with the possession by a prohibited person charges. Today, we heard from 2 witnesses, Trooper Harshman and Sergeant Williams. I'm going to go through the elements of CCW. First, the defendant knowingly carried a pistol. It does not matter why the defendant was carrying that pistol, but to be guilty of this crime, the defendant must have known that he was carrying a pistol. Sergeant Williams testified today that he confiscated a pistol from Mr. Milner's right pocket after the traffic stop. It's difficult to not know that you are in possession of a pistol if it's in your right pocket. Second element is that this pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot be easily seen by those who come into ordinary contact with the defendant. As Mr. Sartz pointed out several times, the officers were not able to observe the firearm initially upon making contact with the vehicle because they were concealed. As Sergeant Williams testified, the gun was concealed in Mr. Milner's right pocket. As for the second firearm that was located in the vehicle, that was located by Trooper Harshman. Trooper Harshman did not testify about finding that pistol today. However, under probable cause standard, Sergeant Williams did testify that he saw with his own 2 eyes Trooper Harshman go to conduct the search of the vehicle and then leave that search of the vehicle with a firearm. I do believe that by a probable cause standard, that does satisfy the second CCW charge for the second firearm that was located. Again, that to go back to the elements, the defendant knowingly carried that pistol in the vehicle. That we know that Charles Milner was the driver of that vehicle when the traffic stop was conducted for an well, not really expired, just for no registration on the vehicle as well as illegal lane usage. Second, that pistol was concealed on or about that person. It was in the vehicle. Now we don't know exactly where in the vehicle. However, by a probable cause standard, I do believe that the second element has been satisfied, that the pistol was concealed on or about that person. It was in the vehicle that he was operating. As for the possession of a prohibited person, I did hand the court at the beginning of these proceedings a certified statement of conviction, certified statement of sentence, I believe is the title on the document. My apologies. That there are several felonies on that document that would prohibit Mr. Milner from having a weapon. One of them includes a CCW. The other includes possession of narcotics. So therefore, with the two firearms, the prohibited person in possession, I do believe is satisfied to a probable cause standard. The elements are first, that the defendant knowingly possessed the firearm in the state of Michigan. We have satisfied that as a probable cause standard, again, through the testimony of both Trooper Harshman and Sergeant Williams. Second, at the time that the defendant had previously been convicted of a felony, we have a possession of narcotics felony, as well as the previous CCW, which is on the certified statement of sentence, and that is a self-authenticating document. As for counts 5 and 6, there's 2 counts of felony firearm to go along with the prohibited person in possession. The elements of a felony firearm, of course, are that the defendant committed or attempted to commit the crime of prohibited person in possession, which I defined earlier. It's not necessary that the defendant be convicted of that crime, of course. And the second element is that at the time the defendant committed that crime, that he knowingly carried or possessed a firearm. which I already addressed earlier. Knowingly possessing the firearm in the vehicle on which Mr. Milner was the driver of, as well as being in his right pocket. So the people respectfully ask that all charges are bound. Thank you, Your Honor.
Thank you, Mr. Sharps.
Thank you, Your Honor. Respectfully, on behalf of Mr. Milner, the defense requests that these counts and charges be dismissed at this time, Your Honor. These offenses were charged in a very specific way because the allegations themselves, while they were similar, carrying a concealed weapon on a person versus carrying a concealed weapon in a vehicle, are similar, but there are some important differences between them, especially as it relates to some of the mens rea knowledge requirements. The people specifically allege that Mr. Milner was on his person possessing a Phoenix Firearms HP-22A pistol, and they used that specific language because they did so intentionally because they're trying to differentiate between the two different counts. Respectfully, defense objects to bind over on count one because there's been insufficient evidence to support the elements of the charge as it relates to the specific depiction or description of this particular alleged pistol that the police troopers, claim that they recovered from Mr. Milner. Respectfully, in a light viewed and most favorably towards the prosecutor, we had a lot of generalities here about pistols and firearms and everything else. But respectfully, they have not met their burden showing which specific alleged item, pistol, whether it was operable or anything else, that it was actual firearm. It would might look like a pistol, but the troopers here were speaking in generalities. And so respectfully, they have not met their burden as relates to count one. Certainly possession, certainly there's an argument for possession on behalf of the people because the trooper is claiming that they recovered some type of alleged pistol on Mr. Milner. But in terms of the specificity for this particular count that should be expected here, even in the context of a low burden of proof, such as probable cause, the people have not met their burden for count one. As it relates to count two, we have so much missing testimony here from the trooper. Respectfully, we had the sergeant claim later that he saw Trooper Hartran go and recover a pistol from the vehicle, but there's so many questions there as to where this alleged pistol was found. What was the make and model of this alleged pistol? And the charge specifically states that this was a Smith & Wesson M&P pistol, but we don't know, for example, where that pistol is located. For all we know, based on the lack of testimony, it could have been anywhere. It could have been on the passenger's person. We don't know. There was another passenger in the vehicle, and in all due respect, there's some serious doubts about Sergeant Williams' testimony. There's a baby in the back seat. How do you claim to be a credible witness up there and testifying, and you ignore the fact that there is a baby? There's an infant in the back seat. How do you miss that? And can you really trust the recollections and testimony of this sergeant when he couldn't even remember something as simple or as basic as who was in the vehicle at the time that he was helping to participate in this traffic stop? So respectfully, in terms of the elements of count two, it's a little bit different. Again, there's an element of mens rea there, knowing. So I think respectfully, the people not met their burden as it relates to the elements for that particular count as well. And similar arguments, of course, are going to carry over the counts 3, 4, and 5, and 6, of course, accompany counts 3 and 4 respectively. So, Your Honor, defense requests that all these counts be dismissed at this time. The people have not met their burden of proof for these proceedings. Thank you.
Ms. Fortuna Gill, Mr. Sarks makes valid arguments as specifically as it relates to, at least from my vantage point, the second count. There was no testimony of where this firearm was located. You didn't even ask or refresh the recollection. Nobody identified the type of firearm. Not that I think that that's germane, but it is important to know where this second firearm was located. It could have been in the purse of I don't know, it could have been in the baby bag. There was zero information provided about that. And so how do I now attach that to this person just because he was in the car that he knew or had reason to know without knowing where this firearm was located? You can respond.
Yeah, Your Honor, I think that under the probable cause standard that he was the driver and he was in control of that vehicle and that he also had another firearm in his pocket. Additionally, there's also the quote from the defendant that Bro and Cook, they took two off of me, which I do think contributes to the probable cause standard that those two guns that were recovered were his.
Thank you. Okay, any other re-argument?
Oh, Your Honor, thank you.
Okay, today was the date scheduled for preliminary examination. The burden is squarely upon the prosecution to establish sufficient probable cause that the felonies alleged was committed and probable cause sufficient to charge you, Mr. Milner, as the individual who committed each of the felonies. You're being charged in count 1 and count 2 with carrying a concealed weapon. We had testimony here from Trooper Calvin Harshman, who stated that on the date of June 5th, 2025, at the area at or near Pennsylvania, the officers could not recall the side street, but did indicate that it was in the city of Lansing, Ingham County, making venue in this court appropriate that Trooper Harshman did conduct a traffic stop due to a registration being invalid and to crossing over the center line multiple times. That when the troopers attempted to run a search of that plate, the registration was not at all listed in the Secretary of State database. The officers asked the driver, who they identified in court as Mr. Charles Douglas Milner, if he had a license. He advised that he did not. He was asked to exit the vehicle, but it appears, or based on testimony of both troopers, that there was some delay in responding to the lawful order of the troopers for him to exit the vehicle. Sergeant Williams testified that he could see, or that he saw a knife, I believe, a pocket knife. Actually, it was Trooper Harshman who testified that the sergeant saw a knife in the defendant's pocket or on his person prior to him exiting the vehicle. And once he did eventually comply with exiting the vehicle, that a search was conducted on his person, and that the sergeant located a firearm in the defendant's right front pocket. I believe is where it was. The defendant was at this point in custody, and there was a probable cause search that was taking place at this point. Officer also testified that Trooper Harshman, I should say, testified that there was a child and a passenger in the vehicle that was ordered to also exit the vehicle. The defendant was arrested for CCW. A search of the vehicle was conducted, and Trooper Harshman said he recovered another pistol from the vehicle. Sergeant Scott Williams testified essentially in tandem with what the testimony of Trooper Harshman was, that neither could identify the type of vehicle that was stopped, but that it was some type of sedan, and that the vehicle was stopped for a registration violation, that the defendant stalled when ordered to exit the vehicle, and that he began to act suspicious in the troopers or the sergeant's view, and it was based on him moving around or making some, I guess, suggested or furtive movements as if he was looking for something or gathering some things. And the officer who testified, Trooper Williams, testifying that he has seized over hundreds of guns based on his training and experience, believed that there would likely be something illegal or in the vehicle, possibly a weapon, that he questioned the subject to which he received a blank stare, and that he observed, Sergeant Williams observed Trooper Harshman search the vehicle and return back with a second firearm. The argument is that the defendant is the operator of the vehicle, and was identified as the officer as the operator of the vehicle, but did not have a registration and he did not have a valid license, which would give probable cause for him to be arrested at this point. And the vehicle could essentially have been searched as an inventory search. They ordered the passenger and child out of the vehicle. At least Trooper Harshman testified to that much. There was a search done of the vehicle, whether it was because of inventory, whether because of the probable cause. I think that the search was reasonable under the circumstances. They've already located at this point on a subject that's now in custody for no license, no insurance. He had a knife in his pocket and another weapon, that being a pistol, in his pocket. And then another firearm was located in the vehicle. It's unclear to this court where that firearm was located in the vehicle, where it came from, whether it was inside of a console, whether it was under the seat, whether it was under the passenger seat, whether it was under the driver's seat. Was it in a baby bag? I have no clue. That is not information that was provided to the court. But what we do have is a statement that the sergeant said he overheard in his presence the defendant on a speakerphone called Big Bro 3 and said, "Bro, I'm cooked," and they took two of them off of me. A reasonable person could ascertain that the two of things of which the defendant is referring to would be the two firearms that were confiscated. I recognize that both of these were charged with specificity, but I don't think that specifying which firearm or which pistol came from the person or at which pistol came from the vehicle for the purposes of probable cause is germane, but that the court is satisfied based on the elements and the testimony that there is sufficient probable cause as to count 1 and count 2. I do have here the people's only exhibit admitted, which was the certified judgment of sentence, which does indicate that the defendant had several convictions that would make him ineligible to carry a firearm. It also appears that he was on probation at the time of the alleged incident. So I don't even know that he'd be eligible to even make or meet the criteria while on probation. Neither here nor there. The court is satisfied that count 3 and 4 of weapons, firearms, possession by prohibited person is satisfied by way of probable cause, and count 5, 6 of weapons, felony firearms will accompany the previous counts that was bound over, and this will be bound over as an habitual offender. 4th offense notice. Your bind over date is going to be August 20th. That's the date the circuit court will receive this file from the district court, not a date that you, Mr. Milner, need to appear in the circuit court. Do you understand that? Your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that, so you'll maintain communication with him, okay? Do you have any questions for the court at this time? It looks like bond was set at 25,000, 10%. Is he having a hold somewhere else?
Yes, Your Honor.
A bond will continue. Any additional matters for the record?
Anything on behalf of the people, Your Honor?
Just requesting the transcript, Your Honor. Thank you.
Thank you. You're all set.
Judge, they have that other, I don't know. is that a show
Oh,
cause?
1 second. I think it's a show cause. Yeah, this is City of Lansing versus Charles Milner, 24-01904. It was $2,100. He's being held on, what is it, the probation matter? Is that what he's being held on? Okay, do you know how long he's in custody for?
I've been in custody since June 5th. I got arraigned by magistrate Milmore last week. My last payment was at the end of May for June, And I explained to her I wasn't gonna be, I didn't make the payment in July because I was incarcerated, and I wasn't gonna be able to make a payment this month because I knew I probably would still be incarcerated, so. Is there any way we could work that out?
Let me get her notes here. I've been incarcerated since June 5th and no release date. So you don't know when you're getting released.
No, I have a hold,
You have a hold with 30 circuit for a probation violation? When's your hearing?
Monday.
Okay, it said, and a defendant advised to talk with his attorney to see if Judge Simmons would address issue.
Oh, Mr. Doyle's here, Your Honor.
Oh, is that why Mr. Doyle's here?
Yes.
Oh, Mr. Doyle, did you know that's why you were here?
No, Your Honor, I'm
I was gonna say, I don't think, Mr. Doyle, I don't think attorneys usually appear on show causes.
Well,
yeah,
Mr.
this is
Doyle's
a-
here on his other, well, Mr. Doyle is obviously observing.
Oh, you're here on the, you handle the hold matter.
Yes.
Oh, got it. So that's gonna have a hearing on Monday to determine what's gonna happen? Okay, and then as it relates to this, you owe $2,100. You don't know when you're gonna get out. I don't know why the magistrate thought that maybe I would address this issue better than she could, but I don't see how I can do anything if you're in custody. So I will reset the show cause to see what's going on with your other matter. I don't know if you're gonna be continuing probation or not, so.
He terminated me on June 17th.
Who's he?
Judge Kennedy.
Judge
Sorry.
Kennedy?
Yes.
Oh, so you'll get sentenced? Okay. Any idea what he's facing for sentence? Okay, I'm gonna reset this for 2 weeks so I can see if he's sentenced. If he is sentenced to Department of Corrections, we'll just do a prisoner remittal form.
Thank you, Your Honor.
Thank you. You're all set. August 29. Thank you.